Think of it. Let me know exactly sort of like what questions you really want to know, so I make sure that I cover, or if I don't have answers, I'll get them for you. I was told to sort of give you a standard review, what the reversal rate is, what costs would be, what kind of jurisdiction the court has, things like that. If there are other issues, let me know. Maybe time on appeal, and that's going to change a lot because we're down to judges. And who knows for how long. We've been down one judge for over 2 years now. Our judges are a panel of 3, gets nominated by the judicial committee, goes to the president nominates, and has to be confirmed. For those of you who aren't up with that, Todd Kim has been nominated for 2 years and never got a hearing. So I don't think the panel for the second vacancy is going over yet. But we're down to, and we just had 2 senior judges retire, another one will retire this summer, and possibly another by the end of the year. So, time of appeal may start to get longer. At this point, 2 cases filed in 2016, the vast majority have been resolved. The court, well, let me start back with jurisdiction. How many of you are from DC, so I know how far I have to go into this? Okay. Almost everything's appealable as a matter of right to our court. 2 exceptions. Criminal case where a sentence is, they're not sentenced at all, incarceration is a $50 fine, or less than $50 fine, or small claims. Small claims come up by an application for allowance of appeal. If the court grants it, then it will become a civil case. We may start seeing a lot more of those because Superior Court just changed the threshold for small claims from 5 to 10,000. So there'll be a lot less civil case. Those smaller cases will not be small claims. I don't know what, Scott, I told you, cases come up, they get filed, we get the notice of appeal, they're screened by central legal staff for jurisdiction. If we don't think we have jurisdiction, we'll do a show cause order. A lot of cases get dismissed, especially civil cases, get dismissed that way, also family, because they're just not final orders. Or they're too late.
I just couldn't hear what you said were the grounds for dismissal usually.
Oh, if we don't have jurisdiction, if the notice of appeal is not timely filed, if it's not a final order, sometimes we have appeals that are filed from people who have no interest in the case. That happens a lot in agency cases, where they appeal when they've won. And you have no real clue why, in agency cases, why they do. So they go away. Or there's something like they're appealing an injunction and it's mooted by a week later. After they're screened, if it falls under one of those criteria, then they go right to Scotty, who then screens it for mediation. One thing to know is that almost every case goes through mediation or multi-door at Superior Court before it gets tried below. So at least the parties should have gone through a modified, let's just put it that, because some parties will go in and say, we don't want to mediate, and they really don't make them do much before they go. But family cases and civil cases, your exception will be all the agency cases that you have. And they just go right to the agency. Talking about agency, one of the things that's important to know, especially if, or in a civil case, if DC is a party, or if the U.S. is a party, it's going to be different counsel on appeal. They have different appellate divisions. You will often find the appellate divisions a lot more amenable than the trial attorneys for the government. I've noticed that, not on the mediation side, but on dealing with the appeals, both DC and the government, or the US, are inclined to concede error if they see error. That, they're not going to litigate a case that they think that either needs to be remanded or looked at. So if you have those parties on the other side, just know, one, they're new on appeal, two, it's fresh eyes on appeal, and three, they're not going to dig their heels in if they think there's a problem. In 2016, 252 agency cases, appeals were filed here. And as of the close of 2016, 150 of those had been dismissed. 5 were reversed. There's about a 2% reversal rate in agency cases. And 27 were still left pending after a year. For civil, there were 311 filed. Of those, 179 were dismissed. 99 were affirmed. Again, 2 were reversed, so about a 4.5% reversal rate. Between reversals and reversal and remands. And for family, 102 were filed. 59 were dismissed. 21 were affirmed. 5 were reversed and remanded, and 7 were remanded, so about a 5% that were sent back to the Superior Court for further proceedings. A lot of that, all of that is property or child issues. Now, when I say affirmed, the court disposes of cases in different ways. I told you about the dismissals on jurisdiction. The other major way that the court resolves cases other than getting to a merits division, and I'd say less than 10% get to a merits division, is through motions for summary affirmance and reversal. About 8 to 10 years ago, the court let the bar know that in those cases that it was appropriate, they would entertain motions for summary affirmance and reversal. So of the civil cases, about 100 of them were resolved by motions for summary affirmance. In 2016, family, 21 were.
I'm sorry, could you explain a motion for summary affirmance?
Okay. Motion for summary affirmance is the party says, here's the case on appeal after the appellant or petitioners filed their brief. Okay. There are no issues, or the issues are clear cut. It's almost like it's a summary affirmance. They have to say that the issues are not disputed. I mean, the facts are not in dispute, and that issues can be decided on case law that's clear cut, already resolved by this court.
So you're basically saying this is an easy case?
Yeah.
Then how does that tie in with the 99? You said 99 were affirmed of the 300.
Probably most of that, a good chunk of those were probably on summary affirmance.
Okay, so most of those were, it sounds like, except for one that seems.
Right.
And is that still a 3-judge?
Yes, motions. The judges rotate on motions every month. There's 3 judges. They change every month, and.
But it's a single judge on each motion.
No, 3 judges.
So 3 judges rule on the, okay.
It's just like a merits, but it's a much more streamlined.
Okay.
And unlike a merits decision where the judges would rely on their elbow clerks, central legal staff that I had handles all the motions matters and prepares everything for the judges.
So Rosanna, in that process, excuse me, go ahead.
No, go ahead.
In that process, is it the same as briefing, so that there's a summary motion and then there's a reply, or not?
It's a party files a reply. And a lot of times it just depends on how complex the case is. That's fine. We see summary affirmances a lot more in the criminal, because right now DC is seeing the skyrocketing number of misdemeanor bench trials, and not as many felonies that are being appealed.
I'm just curious on the numbers for the reversals. They seem incredibly low, which is
They are low.
obviously the rate, I guess. But I'd say, let's see, in the past, let's say 3-4 years, have they ranged somewhere between 1% to 5% generally? And if so, then is there a resource that we can go to kind of as this program progresses that shows these numbers? I kind of self-pitch to those participating in the mediation process. How can I say it? Not necessarily a sales pitch, but just the probability of you getting a reversal is highly unlikely.
Probably I would have to give them, it's not, I had to run like 7 different reports to get these numbers.
Oh, really? It's not an annual report?
Well, the annual report gives some gross numbers, but it doesn't break it down.
Okay. No, this is fine. It's just kind of,
But yeah, when Scotty asked, I'm like, well, let's see what I can do. And about 7 different reports, and I can crunch the numbers.
Okay.
Where's the next, excuse me again. On the report, that's really low from all of the research that we did for our and is that, but you haven't broken it down in terms of according to whether it was a de novo review standard or abuse of discretion, or you haven't diluted.
Yeah, at this point, the numbers that, what we keep in our docketing system, that is
Do you think part of that might be, well, you've broken them out, but I was going to say sort of the average is down because of the deference the court makes in administrative cases?
It could, I mean, and some of it is just the type of cases we get. And it, like maybe about 5 years ago, for agency cases, workers' comp, there was a much higher reversal rate. Because of, right around that time, the court made a decision on the law on what a certain standard was. And at that point, it wasn't being used by the agency. So at that, DC just came and remanded everything.
Oh, wow.
At that point and said, okay, it was the wrong standard, let's send it all back down and get it cleaned up and send it back up. I'm sure there'll be some litigation, maybe some of the cases that are still hanging out. It's because the court went on banc on, was it Fryer or Dalbert, and that's both civil and criminal, and that's just starting to work its way through the Superior Court on like products liability and stuff.
Back to the civil, I got the percentage, 4.5%, but what was the number that was reversed?
I had 2 reversals and 13 reverse and remands. And then there were 8 just plain remands, which means probably one of the parties just said there was a problem, let's send it back down before.
This is in there's a page in your material.
What page?
Well, it's
At the very
number
end of,
22.
Oh, I didn't know if you had put it in.
82.
I
82.
wrote it out.
That's the number at the top of it.
Thank you.
Again, for standard of review, any issue of law, it's de novo. So for civil, a 12b6, a summary judgment, any of those the court would look at de novo. If it's an issue of fact, credibility, it's deference to the trial court. At the agency, it's deference to the agency, except if it's from OAH. We have case law that says they don't have expertise, therefore we don't have to defer on how they interpret someone else's statute. because I know DC for a long time was arguing, oh no, they get deference, and the court finally said, no, they don't get any deference. And part of that is, yes, we give deference for workers' comp, they do this all the time, compensation board, board of elections, but OAH, they don't even have hearing examiners that do specific cases. It could be any hearing examiner that has any case. So, and as OAH just expands on their jurisdiction, this court is like, we'll look at it, we'll decide if you applied it right, and if not, we'll tell you how you need to apply the regs or the statutes.
On the civil side, what's the difference, or can you explain a little bit more? An absolute reversal, remand.
Remand, a lot of times will be, you did make sufficient findings, go down, make findings. If the parties aren't aggrieved, then come back up with your issue. A reversal, a 12B6, the court could say, you were wrong. They don't technically remand in that case, but they vacated the dismissal so the case will go on in Superior Court. Or it could be a reverse and remand where they said, you got some of it right, but not all of it right. Go back down and litigate on this other issue.
The dismissals, the numbers you gave us for dismissals, does that include dismissals by a stipulation of the parties when they reach an agreement?
And dismissal by the court.
By the court.
Jurisdiction.
Right. It could be the court will dismiss because we don't have jurisdiction, or if the court directs the parties to do something, and after 2 times being directed to do it, they don't do it, the court will dismiss under Rule 13.
This may be a question for Scotty, too. How does the court feel about resolutions of cases which call upon the decision below to be vacated and lose any precedential value as a result?
Okay, we get them mostly in the criminal, and if we get a motion to dismiss, or it will come in as a motion to vacate, the court, by chief judge order, can vacate the judgment below and remand to the trial court for further proceedings. We don't usually get it in the civil, but we do get in the agency, especially if DC is trying to settle, it's to say we've reached a settlement, hold the appeal in abeyance, because it's got to be approved by the agency. And once the agency vacates, says they're going to vacate their order and approve the settlement, then the parties will dismiss another appeal here.
I'm thinking about a scenario in which the settlement requires the vacatur of the decision below, so that if the Office of Administrative Hearings or a civil division issues a memorandum opinion, it's published on Lexis or Westlaw or whatever, it has some precedential value. There's a party that doesn't like the law that's contained in that, and ultimately can the settlement that's reached require the decision that was made below to be vacated and lose any precedential value as a result?
I would say if both parties agree to the vacation of the order, that the court probably at that point would go ahead and vacate the order based on the settlement.
It's interesting issue, because it means that if you have a settlement agreement that is dependent on a third party or a third body doing something in particular, that it could fall apart. So sometimes parties stipulate, they say that they will stipulate to a motion, but they don't make the settlement dependent on whatever actions taken there. In California, they have to prove in a motion to what they call stipulated reversal. So they want the court to reverse it, and that where a remand is in the trial court. But in either case, there has to be a showing of a number of things, but one of them is that the public doesn't have an interest in it.
Uh-huh,
Right.
yeah.
So I don't know if there's anything like that in DC, or the parties are sort of free to do it. That used to be the law in California, and then there was a huge sort of uproar with the decision, which was codified.
I mean, in my years, I don't remember seeing it in civil. I mean, we see them all the time in criminal, but not, and an agency. But that's just basically usually for an amount, not because of an issue of law.
I see.
Now, if the courts come out with a new opinion, and there are all these cases, and then we may vacate and say, we're going to vacate the order on appeal, then we'll remand it for you to reconsider in light of the new case law.
I think if that comes up in one of your cases, then it will probably be something that we would have to talk with, obviously, Rosanna and the chief judge about, because this is new ground for them.
Mm-hmm, yeah.
You know, I know in Maryland, when we had cases where that's definitely a term of the agreement, and we discussed those cases with our chief judge to see whether or not the court would have any concerns about dismissing or vacating that type of order. So normally, if it was a judgment, there was no problem in getting it vacated. But if it was anything to do with contempt or anything of that nature, then that court had a blanket policy that those would not be vacated.
I was going to say, I can't think, well, no civil case would have any precedential value anyway until affirmed by us. So are you thinking more of agency cases where it's their own interpretation of the statute?
That might be the more likely scenario.
And then I think it would just depend on the court at that point.
Sometimes parties just don't like the idea of having an adverse judgment out there.
Right.
Like maybe for business, even though that it hadn't been affirmed, that it was still on the books, so to speak. Or, when I was at the Ninth Circuit, people who lost licenses and then settled, and that was an instance in which, and I don't remember the Ninth Circuit standard, but I think it was pretty similar, in which the public might have an interest, and there had to be a motion, a special motion made before the board who made the decision in the first place. So it was done at the trial court, at the administrative level.
Yeah, in the civil court, it would be a money judgment. It would be the opinion and then a separate money judgment. And that would be vacated via the settlement, but maybe not the underlying opinion.
It's an interesting question. I can imagine a scenario where there's an opinion on an evidentiary issue or a procedural issue that has been issued in Superior Court, but might not have the precedential value, but everyone follows it, and the lawyers don't like it. Is there anything that you know of that has sort of the public interest criteria, like in California? Does that exist here? Do you know?
So it sounds like if we're in a mediation, then that's a term that's tentatively agreed on. We sort of can't quite bless it. It has to be blessed by more important people.
By the court.
By the court.
Right, which is subject to, yeah.
Right.
And we would have to tell the parties that
Right.
that's the routine we have to follow.
Right.
Okay.
They could only agree to jointly agree to file something to that effect.
Right.
Request, the
But-
request,
Uh-huh.
yeah.
Yeah, I would think in that situation, it would be a motion to the court to vacate the lower court order to allow for the settlement, and then the settlement would be contingent on the courts. And that, I would think that kind of motion on that kind of issue would go to a motions panel, not a chief judge. Because it's more of a legal issue, not a procedural issue.
I wouldn't have with that have on, if at some point in time, the parties have to be enforced have to go before the court and have the settlement agreement enforced. I thought my understanding was that the trial court still has jurisdiction, and so, let's say down the road, one party says, well, we're not complying with the terms of the settlement agreement. And so, if that judgment is vacated, then guess, how is the trial
Oh,
process?
well, because more than likely, you would register the settlement agreement in the trial court.
Which would be what the.
Right, and then it would be the trial court to enforce, whether it's filed under seal or.
I was just concerned about this.
And for agency, then it would be the agency. And there's also a petition for mandamus, which is what we see more at the agency level, where something's been told for the agency to do, or if, say, there's a settlement and they're not doing it, say recalculation, then we get a mandamus petition. That's usually enough to move them along.
So as a routine matter, if there's a settlement in a fraud case, the attorneys will file that with the trial court, or do they just hold on to it if the settlement is not compliant with it?
If it was me, I'd file it in the trial court, just so you're not having to fight about it, please.
If confidentiality is a concern to the parties, then, and that may be, that's sometimes a term of the settlement. So
But you can file it under seal.
okay.
Yeah, I mean, a lot of, in the civil cases.
That requires a motion?
Yeah, all the civil settlements need to be filed under seal.
So I want to make sure I understand this. So if you've got a judgment for $50,000 that's being appealed, and you mediate it and you reduce it to $25,000, what happens? Where does that go? And then the party fails to pay within the 30-day requirement, what happens?
Okay, so you basically agreed to a remitter. So then you would file that in the trial court to have a judgment amended to the 25, subject to whatever the other terms are, and then if there's non-compliance, you would go for compliance in Superior Court.
So when would you file something here? I mean, in this, what are the circumstances that it would be filed? In a case what would be the circumstances? What kind of case, what kind of resolution?
Generally, we don't care. I mean, what we would expect would be a motion to dismiss, subject to settlement, because we don't enforce the settlement agreements.
So that's it.
Just sort of procedurally, logistically, I could see getting into a, pretty quickly, right, you come up against these kinds of issues, and because I do not litigate as an appellate, attorney before this court, would want to double check my understanding of what's possible. So in that case, sort of reach out to you, might get on the phone and
reach out to Rosanna
to figure, we're taking a 5-minute, 10-minute break, and okay,
and we'll get an answer.
because I'm sure that is very likely the first time one of these issues.
It may, and if we can't get an answer for you that day, it may be that you have to recess the mediation with, in order to get the information that's necessary.
Okay.
And then I would also ask the attorneys to go out and, do their due diligence and see what information they can find on their own.
Okay.
So, Rosanna, if we didn't have mediation, but people were negotiating directly and they had these same kinds of questions, can they call the court and ask?
They usually get kicked to me.
Pardon?
They get kicked to me.
Yeah, because that might be, because the telephone game, lost in translation. And so you could probably do well to say, well, here is a resource, you need to check this out for yourself to see whether it's doable. But there's a resource in the court, and you could call Rosanna and take yourself out of that, unless there's no way around it, because.
Another alternative is some kind of procedural guide.
I'm sorry, I can't hear you, Grace.
Another alternative is some kind of user-friendly procedural guide for the litigants. At the trial level, and the criminal trial level, there's a practice manual that's available to the litigants. But some handy-dandy little, resource guide that might be 2 or 3 pages with just, here are the general procedures, here's what's available. That's just sent out to the litigants as a matter of course, that advises them on, just basic procedure. Even though they all have to know the court rules, et cetera, it's incumbent upon them to do so. If we want to be encouraging the process and be as educational as possible. Maybe that's a good idea. I mean, is that something, I'd be willing to, help do that.
Like the opening letter to.
Yeah, no, I mean, I don't know what the rules are, but I mean, I'd be willing to work with you to do something like that.
It's just a question, Grace. Is this a thought that this would be specifically for litigants in mediation or appellate practice in general?
In mediation, the people we're going to be working with, right? The community we'd be working with, the litigants, if they elect to proceed to mediation, then kind of a, here's a little how-to. It's just a thought, but it would be, it might be helpful.
Actually, I think it's almost like instead of we're not giving them, and we can't give them legal advice, and maybe it's in the paragraph that talks about how mediators are neutral, not giving you legal advice. You're going to want to understand that it may be you may need to file something here, you may need to file something in trial court, because you may have attorneys who aren't thinking, they're thinking linear as opposed to creatively.
Right, just just basic guidance available to them.
Right.
That could be helpful.
That's something we can look into, as I understand the procedures here for the court publishing anything of that nature.
We're working on it.
Okay.
Yeah, now that we've killed the backlog,
Okay.
that's the next thing on the list.
And then it goes through stakeholders review as well for certain things.
On the ones that are already on the web, which is, okay, I have a writ of eviction, I'm going to be evicted, what do I do? What do I need to do for a stay? And certain things like that. We do have some of that on there now. But as far as, there's also an appellate practice manual that legal did 10 years ago that we've got to update. But what, for the website, I usually, we write it, I send it over to someone to put it on and make sure it's on about a 9th grade reading level, and then get approval by the judges, by the board of judges before it gets up.
So I guess the suggestion just to have a piece in there that is specifically for mediation.
In lower courts, when we mediate, it's usually a default provision. Parties don't do what they promise, there'll be a judgment entered upon motion. In appellate practice, is there any similar kind of a default provision, or it's just left for them to enforce whatever's been agreed upon?
I would think it would be up to them to enforce the Superior Court, whatever was agreed upon.
Because it gets remanded from this court.
Right.
Once it's settled, it's
Once it
remanded
settles,
to Superior
yeah,
Court.
jurisdiction gets transferred back to Superior Court or back to the agency. So this court no longer has jurisdiction.
In the case that we are mediating, if the parties reach a new agreement at this point, lowering the amount or whatever it is, do we just, this is now the agreement, or is there, if upon failure to comply within 30 days, what next happens? Should
I
it
would
be
hope
put in-
that would be within the agreement in itself.
That can be discussed in the mediation. If the conditions are not fulfilled, then what will happen? Will the appeal then go forward? Will there be penalty provisions, et cetera, et cetera? So that's an issue that we bring up in terms of passing through the settlement.
Right, the statutory interest right now on a money judgment is 3%, unless it's by contract. I mean, you could say so-and-so, it's at the statutory limit, however, breach, it's 6%. I mean, there are a lot of different things that could be done in the agreement.
Well, at this point, because the case goes back to the Superior Court, but however they resolve cases and whatever they do in Superior Court so that the court retains continuing jurisdiction to enforce the agreement, it's the same. So somebody mentioned there might be a stipulated judgment that is, changed. I think it was you, Rosanna. You stipulate to change the judgment from $50,000 to $25,000, and the court still has the jurisdiction. In California, there's a statute that you can cite that the court has continuing jurisdiction. In some cases, there's a consent decree and there's oversight by a third party. So there are all of those things that are available, but the important thing to know is this court's not going to get involved in that. They don't have jurisdiction anymore after the case is settled.
Yeah, and if it's money judgment is being reduced, the big thing is to get the judgment in Superior Court reduced. And then it would be, you'd enforce it like any other judgment in Superior Court.
I have a question for you, a couple of questions, Renee. You said that there's deference to, except in the OAH cases, there's deference. So what are the magic words that apply to, what is the standard for, when you say deference, what's the test?
Basically, the court's going to defer unless they think that their interpretation of their rule is just so out of norm.
Is it clear?
Is it clear error?
Yeah, basically. But you could say, I mean,
They're still just words.
yes.
Yeah.
It's like for the gross, you know, the various levels for unemployment. Gross misconduct, I mean, that was one of the ones that, everything was gross misconduct until this court said, oh no. Your way of applying this to way too many cases. This is what really gross misconduct means, and gave a whole rubric basically, and then all those cases got remanded. So that was 1 year when the remanded reversal rate was high, just because the court came out and said, no, how you were applying the rule, in light of the intent of the statute, is just too harsh.
And what about abuse of discretion standard?
It's basically clearly erroneous, or that there's no evidence to support the factual finding. So it's a pretty high standard. Anything else? Okay. How about if I just take questions? If anyone's got any, on something I didn't cover.
So we, in a situation where we have a particular kind of case, would you be able to get into your computer and say, with regard to cases having to do with some DC government, what's the affirmation, the percentage, that kind of thing? Can you parse it that way? Or
I could probably do that because that would be by a party, by a representation. So yeah, I could probably get that by running a few different reports.
How about cause of action?
A little harder,
But it's possible?
maybe. I mean, we got a new docketing system a few years ago. The information I get out is only as good as the information that gets put in. And when the cases got converted, a lot of that information became God knows what. So newer cases, yes. Older cases that got converted, I wouldn't trust the data as much.
Older cases were 1 year back.
I'd say pre-2015.
Okay.
That's not so old.
What proportion of the cases are brought by pro se appellants?
At least a third.
So we won't get those.
Yeah.
You will only get attorney cases.
Let me qualify that. And that's one of the future plans, is to ultimately bring the cases with pro se litigants into the program. However, only if the pro se litigants are represented by attorneys. So our numbers of cases will increase, but we'll still just be dealing with represented parties. That they would have started out as pro se.
Being appointed counsel.
Pardon me?
Being appointed counsel.
Not appointed, it's limited representation.
Pro se means not represented, so.
Right, so I still think of them as pro se because that's how they started out, and that's the way they would come into the program. But if the case is determined to be appropriate for mediation, then the parties are going to be given the option of working with an attorney, and we're going to develop a panel or a group of attorneys who are willing to take these types of cases, you know, whether it's clinical students or attorneys in private practice. So the quality, the case is going to differ in terms of what happened below, because at that point the person would have been pro se. But when you deal with them, they will be represented.
Yeah, you had that one that the motions panel picked,
Right, right, and I,
the L&T case.
right, and I found an attorney through DC Law Students in Court, and that case settled.
One more thing about statistics. Statistics, it depends on how you calculate it, but I think one of the reasons that it came out so low is you calculated the total number of cases and then how many of those total number of cases were reversed and so forth. Another way of looking at this is if your case, in the case of these, they survived, so far they've survived dismissal, involuntary and voluntary, so you could, I think, fairly represent. And I did that, if you look at page 82. I don't want to mislead people, so I'm curious about what you think about this, and you too, Scotty, but if there were, of the decisions, if you just take the number of decisions and then look at how many were affirmed and reversed, the statistics are much different.
You're right.
So I think that you could explain that overall, we've had this many these many cases get filed and there's only 1%, but when you're looking at the disposition of the decisions themselves, that's pretty significant. In fact, I ran that by my co-author, because he's the math wizard in all of this, and he said that those are really high statistics. The ones that I came up with, that was really high. So, and I have some information here that's sort of generally across the board, but I really think it's important to think about these agency cases that are affirmed very frequently, and that's true. And but there are higher reversal rates for some other cases and lower. Whenever the government is a party, there's a way lower reversal rate, I think, but nationwide.
Well, the part of that is too, probably only 10% get to merits. Everything else gets resolved beforehand. So, when you look at affirm reverse, those numbers are going to be smaller just because a smaller number actually gets to merits.
Yeah. Yeah, look at this, this one that we just looked at, it's a third of the list.
So I'm assuming that cases that are susceptible to summary affirmance or reversal are not likely, correct me, to be subject to mediation because they're imbalanced.
Not necessarily.
Not necessarily. Would it be fair to say that most of the cases that we would have are the ones that would go to a merits panel, perhaps to have an oral argument, and then result in a written decision?
No, because you're getting them too early. You're getting them right after jurisdiction,
Right.
before briefing, before record, before anything.
So they don't know at that point which way it's going to go. The parties don't know because the court hasn't decided whether it's going to go to a motions panel or whether it's going to go
Now, one of the parties may think, this is a stupid case, I'm going to file a motion for summary, once it's the record and transcript is here.
So, one of the data points that mediators may use is that is the time question. So that do you have any statistics on the length of time between the filing of the appeal or the petition for review and an ultimate determination by the court in administrative, civil, or family cases?
Yeah, they should be in the statistics the court just put out for the
That's in the
annual report. Yeah.
That's okay. Is that something that's in our notebook?
No, but I
No.
go forward.
Oh, okay.
It's online too.
Okay.
And for a while, central staff was very understaffed. There was a delay of about 7 months from a motion for summary disposition to it being resolved, one way or the other. Right now, we're looking at 40 days from the time it's filed till it's resolved. No more than 60. So that's a lot. So it just depends, it depends on what kind of case and how quickly it's going to be resolved.
Actually, I think I saw that the stat on the average time of appeal, I think it's 403 days.
Ms. Howell?
403 days at this point. There were outliers on either side of that, obviously, but that was the average.
Yeah, there was that one en banc case that was 3 years old, so that skews some of the numbers.
Just, I guess the question for both of you, Scotty, if you're talking to counsel about whether a case is appropriate for mediation before you assign it to us, and one side or the other says, oh, we're going to be filing a motion for summary affirmance or dismissal, if the statute of limitations was, the issue down below and it's obvious on the papers, then you wouldn't assign that to us, right?
Well, not necessarily. They still may have a reason for mediating. There may be, the challenge in screening is trying to figure out some other, and I hate to use this language, I shouldn't use this language, but sort of pressure points.
Okay.
If there are other aspects of the case that would make it attractive to that party to engage in mediation.
You might be able to convince them, but if they say, no, absolutely not, we've had 12 of these cases and we know what we're going to do, then, I mean, if they're bound and determined to do that, we're not going to get a case where someone's that resolute about filing a summary motion.
No. But
So we won't get won't get
That
many
seems
of
to be
these.
right, yeah.
And one of the things too, I mean, the court for like dismissals sort of for pro se, but really leans backwards. Is there anything in this complaint? I mean, a lot of times those get sent back down, saying, okay, look at it, yes, unless it's fraud, they have to be specifically pled. They're much more likely, if it's just a dismissed 12B and not going through anything, saying, trial court, you've got to do a better job. At least tell us why. You don't think they've pled enough.
One of the things I'm curious about is the stay is indefinite. The appeal is stayed indefinitely while the mediation proceeds, right? And I guess it cuts many ways, right? Whether it ought to be time limited or not. But is there a trick? There's no trigger. It's just indefinitely stayed, and there's no.
At this point, there is. I personally think there should be, but it also doesn't stay the judgment. Unless they agree to stay the judgment and the money judgment, they can go collect. So
the reason why they're stayed is because you want to be able to tell parties that,
I just mean indefinitely stayed. Because the pressure on having some kind of time, some kind of deadline for the stay to lapse.
Right.
Creates a pressure point that cuts many ways, I suppose.
I think you do have the time frame. That's why you have the 45 days for the initial session. And then that's also my job to monitor what you folks are doing and check in with you. I wouldn't say monitor, that's a bad word. But check in with you to see how things are progressing, because all along the way, we can have discussions about whether it makes sense to continue the stay. So, there's flexibility. It's been my experience that, approaching these cases with a one-size-fits-all process is not really helpful, and it really can be such a great tool if you have flexibility to tailor the process to that particular case and how it's proceeding through the system. So,
I understand. Yeah, I mean, at a different level, I've always found that having a time limit on the stay forces the parties to do, not to be forces the parties to take action and hold them accountable in a way that, ends up being helpful in getting an agreement.
right, it depends on the type of case as well. So, for example, that approach is very, it's probably very applicable in a civil case, not so much in a family case or a probate case.
You're doing probates?
We haven't had any.
I don't think there's something to. I thought you were doing probate.
That's why I haven't had any. We're all learning something.
Because that was going to be one of the questions.
Yeah.
Because there are lit cases and probate cases, which are basically contract cases.
Right.
And those I can see going to you versus a millionaire screaming at each other about a will. It's an issue of law. Going to some.
Right. Probate cases are actually great for mediation. There's really juicy. I mean, they take a long time, they're a lot of work, a lot of direct contact and interaction with the parties, but, but yes, we do want those cases, don't we?
A lot, I was going to say, a lot of the probate cases we're getting now are being filed by the attorney PRs that aren't getting paid because they're not doing what they're supposed to. And the court's saying you don't get paid. And the court's not going to say, you know, that's not something to mediate.
Right,
So,
right. When you have those the family that are fighting over that last little tchotchke, you know, and we need them. Mediation can be very helpful.
Is there a sort of a community understood or recognized metric for determining what the average attorney would charge to pursue an appeal in a civil or family case? I mean, it's sort of known in the community that it typically would take, say, 80 hours to assemble the record and draft the brief and prepare for oral argument if it goes that far, or 100 or whatever, times X amount. So the mediators get a sense as to what the costs are to the parties in the absence of some other fee shifting provision. That, you know, it's going to cost you $30,000 or 20, whatever the number is.
well, the transcript's going to cost you $5 a page.
Transcripts are 5, okay, well, there's.
And how many pages per day of trial?
That's-
A few hundred, at least, yeah.
I want to also say that you can also ask the lawyers to do that beforehand in the pre-mediation call.
Yes,
and
true.
in my follow-up letter, I typically say, you know, be sure that you speak with your client about the costs, and they can tell you, but this is something important. I don't know you said this. I think you said it to me, or somebody did, that a lot of maybe it's you, Jack, a lot of the people who appear as lawyers in this court aren't really appellate specialists. They're just, and they may not have much experience with appeals. So and we have some statistics in our book, I'll pull them out, in terms of what you can expect. But you know, I've had a case in California, but it was multi-party and long trial. You know, and the fees were close to about $800 to $1 million on each side. So there are some where they're very significant.
Well, yeah, and your family, I'd say you've got 3/4 of a chance of getting someone that does family law, appellate work. Workers' comp, the same thing. PI maybe.
That's a big verdict.
Or if it's one of those firms that just does a lot of PI work. Civil, it depends. It depends on the type of case.
I think it's always great to ask the question of the attorneys and, you know, give me a ballpark range as to what this is going to cost you, and then, you know, we haven't gathered that data, but.
There's no way.
Right.
You wouldn't get it.
Right, but we'd have anecdotal.
Yeah, and it would develop.
Yeah, I guess.
Well, check in with some appellate specialists if you have any. Maybe at some point there will be some on this panel. 'Cause they're such great resources. So, you know, just call them up and say, you know, I have a mediation, it was a 10-day trial, there are 5 issues. What would you charge to take this forward?
A lot of times it depends on who's on the other side. On how much it's going to cost.
Yeah, that's true.
And the other thing to know is if you got a case that DC's on the other side, and it's a huge settlement, it's going to take them at least 60 days because they have an enormous number of steps they have to go to, and depending on how big it is, either the mayor or the council's got to sign off. So.
And DC does not pay for transfers, correct?
It would.
Yeah, they do. Well, they have some fund that does, but yeah.
So that sort of little tool is very useful in those cases.
We were getting a lot of, though I think they all settled just before argument, which were the unlawful conviction civil cases. We had like 4 of them that they kept dragging out, but ended up settling just before argument on each one. But that's one of the bigger cases.
Unlawful what?
Convictions.
Unlawful.
Convictions, criminal convictions.
Oh, I thought you said of civil cases.
Yeah,
They
but
are-
they filed civil suits for damages. Under there's a new statute in DC that allows for payment for unlawful convictions.
So you're saying for innocent, people who are innocent released?
Okay.
And
Yeah,
then
they
say,
yeah, they need an innocent certificate. Yeah. And they were about 5 million plus for, I think is what they eventually summed.
Do you have either statistics or a general feeling for what proportion of the cases involve just money versus other issues?
Well, landlord and tenant's going to be tenancy, more than likely, unless it's a commercial lease. At least 70% of civil, I would say, is money. Family, they are if there are kids involved, it's also going to be the kids in addition to the property settlement.
And the DC agency cases, is that usually?
They're going to be money, whether it's workers' comp, the ongoing compensation, workers' comp, unemployment, fines, from OAH, a lot of fines. You're not going to get any board of elections. You probably won't get any of the licensing. You're not doing licensing, because that's up to a licensing board.
Right. We did mediate in one of those, and it settled, so.
Well, if it's a temporary suspension versus a full suspension, maybe. But,
Do you get like zoning, land use cases?
yes, we get a lot of zoning cases. But again, those are, right now, because of all of the revitalization, most of them are HUD applications. So I can't imagine those being settled either, but maybe. I know the court just reversed a huge one this past year that vacated numerous orders and said you didn't take something into consideration. So that whole project is up in the air now.
Sometimes decisions like that motivate the parties, in the subsequent cases to try to get them resolved.
Except one party wants no development. So it depends.
Are you assigning attorney discipline cases to mediation? No.
I can't imagine the court giving that up.
No, but as far as the volume, there are a lot of them, so I'm just curious.
And they're also handled quickly these days. Unless they're hotly contested, they all go through motions now.
Okay.
Very important.
Okay, my direct line, if someone needs to talk to me.
Write this down, How about me?
2718.
Okay, thanks, Sandy. 879-2718.
271.
Since I never called myself.
Thank you.
Okay.
Thank you very much.
Thank you,
Thank you
Rosanna.
very much.
It's really great. Okay, we're going to have some activity, but not just yet. So why don't you just stand up, stretch, turn around, punch your neighbor, touch your toes.
Touch my toes.
Not punching the neighbor.
No.
The neighbor's toes.
No, I wrote one picture before I was lifting my elbow.
Oh, yes.
Can you get back?
Of course,
Okay, good. So we're going to spend a little bit of time about sort of introducing you to the process. And then we'll move on to listening. So this will be a quick trip down the appellate mediation process. So I think my first training, my back and started, my first training in that I did in appellate mediation, well, the first one I did actually for a big court program. When we put in the proposal, my co-teacher and I came up with the principles that we both adhered to in our work and that I certainly adhere to in my appellate mediation practice. And what they consist of are a few basics. And some of this may resonate with the approach that you all take to mediation, and some of it may be different from that. And so it may be a stretch for you, but basically it's consistent with what Judge Rigsby said, which is we're really looking here to give the parties a chance to have whatever kind of conversations they could have, to feel some satisfaction that their problems are solved, maybe not simply by making a deal and cutting a compromise,